Let's say I need to prove that Vitalis is the son of Toricus. How do I go about this? Well, Exhibit A. This stone actually says it there. It's also got some Ogham writing down the side. But the problem, that is hearsay. So what is hearsay? It's something people get confused about, so I thought I'd do a little bit of an overview. Hearsay is generally where you try to use an out-of-court statement and admit it to prove the truth of its contents. So what's that then? Well, out-of-court statement, it's fairly straightforward. An in-court statement is somebody giving evidence in the witness box, and also certain types of witness statement that are just accepted unchallenged because they're all signed there with a statement of truth. What's the rationale for that? Well, the idea is that evidence where it's in court and can be challenged and tested is going to be more reliable than evidence outside court where you don't get an opportunity to challenge it or test it. However, there are exceptions, and we talk about exceptions to hearsay, but it's important to distinguish between true exceptions, that is, where something is hearsay but is admissible, and things that appear at first glance to be hearsay but actually aren't, and therefore they are admissible. So what are some of the exceptions? There are lots of these. Our American friends talk about the 27 or 28 exceptions to the hearsay rule, but it's hard to categorise them. Generally though, there are things like, for instance, what we call statements against interest. Now remember, the rationale is that statements out of court, they might not be reliable because they can't be tested. However, a statement against interest is something where somebody says something that is against their interests. This can arise in a civil or a criminal context. I mean, the obvious one in a criminal context is confessions or admissions, either made in a police interview or incriminating things said at the scene of a crime or afterwards, or when people are talking about a crime they may have committed, or even a civil wrong. Because the idea is that while people might be motivated to say things that are self-serving, saying something that actually is detrimental to you, why would you say it unless it was true? So that's the idea why statements against interest, even though they are hearsay, are allowed in. So you can say things like, I heard so-and-so in the pub admit that he had done that. Now this is to distinguish between, proving that the statement was actually said. Hearsay arises when we accept that the statement exists, but we're arguing it's inadmissible. If we're saying, well, actually, no, he never even said that, that's a different issue. Another interesting one, and especially as we're sort of in a very nice cemetery, is dying declarations. Dying declarations have been admissible in cases of murder where the dying person can say who actually did it. The reason there is, why would you lie on your deathbed? And this originates from sort of the old days when perhaps people were more religious. The test, though, is that you must have, quotes, a hopeless and settled expectation of doom. In other words, you must know you're about to die. So if you sort of say, hey, that Bob, he's the right one, and he ripped me off or he punched me or something like that, and then you get hit by a bus, that doesn't count. But what are some of the other exceptions where things can go in? Well, like I said, these aren't exceptions. These are where the statement is going in, but not for the truth of its contents. A common one is what we call res gestae, which means the circumstances of the case. So let's say, for instance, there's been a big punch-up in a pub, and people are giving evidence, and they might say something like, oh, well, Charlie said you spilt my pint, and then Bob said something horrible about Charlie's mother. That can all go in to show just the context of how the fight arose, but it's not going in to prove A, that somebody actually did spill somebody's pint, or B, that those disparaging comments about his mother are true. So they're all allowed in. Generally speaking though, although it's hearsay, in civil proceedings, hearsay is actually just generally admissible. You're supposed to put what we call a hearsay notice in, just saying what the hearsay is, why it's going in, why can't you get sort of better evidence of that, why can't you get the person there. But it is generally admissible. It's also pretty much now admissible in criminal proceedings, although you actually have to make an application. It doesn't go in as of right. So you have to say, look, this is what we want to put in, this is why we're putting in, this is why we can't get the relevant person there. and also why, you know, there's no other alternative. The mere fact it's admissible, though, doesn't mean anybody has to believe it. In civil courts, judges are allowed to give such weight as they want to hearsay statements, and that can be no weight at all. You can also put in multiple hearsay. You know, Alice heard Bob say that Charlie said that Doris did so-and-so. You know, that's multiple levels of hearsay, but theoretically it can go in. Although, again, the further removed it is from the original, you know, speaker, the less like weight that might be put on it. And an interesting one, actually, just to do an anecdote about this idea of self-serving statements. Police interviews, generally speaking, only, you know, statements against interest, in other words, self-incriminating statements, are admissible. And had an interesting case where the judge was a recorder, part-time judge, and actually was a barrister with a civil practice, not very familiar with criminal law. Now, my client had allegedly sawn somebody's arm off. And our defence was that, no, we went round merely to have a word about collecting a debt from somebody, and he attacked us. Luckily, we had a saw, there was a saw there. So we picked the saw up, and as the person attacked us, we raised the saw, and he caught his arm off it. But he attacked us again, so we raised the saw, and as it happened, we managed to block his arm again. This repeated until his arm fell off. Now, my chap was charged. The alleged victim had chosen not to come to court, which is probably very wise, actually. But the prosecution wanted to go ahead because they wanted to put the interview in. And they said, well, look, this is such an implausible account. The jury are going to go, no, it's clear that this was just somebody going round to enforce a gang debt. And that's how this happened. However, the judge of his own volition refused to admit the statement because he said, no, this confession is purely self-serving because it's just him trying to get himself off the hook, so I'm not going to allow it. Now, technically what we call mixed statements, where some of it's incriminating and some of it's exculpatory, they generally are allowed in, but this judge said, no, I'm not allowing that in. Actually, it was quite funny because I just had to sort of go, well, you know, you're the judge, can't really argue with that. And it was actually the prosecution going, no, but we need this in. And anyway, it didn't go in. And they had to offer no evidence because that was the only evidence that was there. But yeah, like I say, with regards to, you know, statements that sound like hearsay that aren't, you might have something where somebody says, why did you do something? Oh, because somebody had threatened me and said they were going to do something. That statement can go in, not to prove that the threat was real, but to show why somebody acted. It's quite common that you can put something and say, we're not saying the words are true, we just want to put in to show the words were said. For instance, you know, why somebody was provoked or why somebody did something. Also, for instance, say I write, Alan is great on a wall. That could go in, not to show that I am great, but it could go in to show that I was actually present at the scene and I'd written that. There's also been cases where, for instance, adverts for drug dealing, you know, best prices in town on weed. That has gone in, not to show that the person has the best prices in town for weed, but to show that they are a drug dealer. So I hope there you can see the distinction, you know, what actually is hearsay and what are the exceptions. Like I say, in practical terms now, maybe it's not as important because, like I say, in civil proceedings, they do go in generally. And quite often you can get relevant hearsay in criminal proceedings. And when I say statement, it can be spoken, it can be written. It can also be actions. There was a case where somebody in a case where they were trying to prove that a ship was seaworthy, they gave evidence that the captain put his wife and children on board the ship and said, well, look, that shows that at least we thought the ship was seaworthy because the captain wouldn't have gone to sea with his family if he didn't think that. But they said, no, actually, that is hearsay. So there you go. So it's not just words, it can be actions. But anyway, hope you found that, as always, vaguely interesting. If you did, please consider clicking the like button and subscribing, because I actually reached 9,000 subscribers the other day, so I got very excited and happy about that, so thank you.